Welcome to the Good and Basic Podcast, a long-form conversation about the projects we do and why we do them. We are Joseph and Joseph, and today we are going to talk about a paper that Joseph is writing for his law class.
As such, it is a work in progress. Please don't judge me too much.
Didn't you say you were handing it in this morning?
Oh, no. Handing it in this evening. So there's still hours in the day.
All right, we'll try to get out of here as soon as possible so that you can write a good draft, right? So we did this a couple weeks ago where we talked about my master's thesis. This is going to be kind of similar, although I think it will relate a little more clearly to our channel. If I understand rightly, I'm not the one writing the paper, obviously, but if I understand rightly, the idea that you're putting forward roughly is that case law made by judges, right? The decisions that judges make, and particularly the incarnation of that in the English common law, is sort of a more appropriate technology for making legal decisions, for making laws, than the legislature.
Or at least that it has its place. At very least that it has its place.
Rough sketch of the idea.
Rough sketch of the idea.
Okay, perfect.
And then it ties in a little bit to some things that I've noticed about the American Constitution, and it's just really interesting. I'm finding, that there's a place for rules made by judges.
Okay.
It's kind of a cool thing.
So why don't we, a lot of our listeners may not know a whole lot about the law, so let's sketch out things in a broad outline for just a second here and kind of set the stage for the argument you're making.
Sure. Basically, there are three more or less classes of law, and in America, they more or less correspond with the three areas of government. So the most basic and most recognizable to everybody is the legislative law. So the legislature makes statutes. After a bill becomes law, it's called a statute. And when you have lots of statutes that are related together, it's called the code. So you create a code.
And that's what legislatures do.
That's what legislatures do.
Congress, for example.
And you think about the process that makes that law. The process that makes that law is you get a bunch of people who were elected in a room together, you have them argue about what's the best idea, and then they get carte blanche to write laws. If they think something is a good idea, they can write it up as a law. Mm-hmm. Okay? Yeah. So that's legislative law. It's called statute. The second category of law is law that is made by segments of the executive branch. So this includes all the ABC soup organizations, CIA, FBI, FTC, FAA, EPA, all the rest. And when they make laws, they're called regulations. Now, the authority that they use to make law is an extension of both the authority of the legislative branch and also the executive branch.
So this is the legislature who says, okay, now there is a Department of Education. Now, Department of Education, go make rules about education.
Exactly.
It's functionally delegated power.
It's delegated power.
Okay.
And typically what they'll do is they'll say, hey, we want the laws to more or less do this. Can you go ahead and make them do that, do research, figure out what works, and then you make them.
All the specific regulations.
And that raises problems because for one thing, it's really hard for the legislature to keep track of what all these agencies are doing. For one thing, there's a lot of them. For another thing, they make a lot of rules. And the way that these rules are made is based off of smart experts saying what they think should be the case. However, these smart experts are not
technocratic and bureaucratic.
Technocratic and bureaucratic, but the people tend not to be elected. So
never.
It can raise problems. So, you have the advantage of smart people making decisions about things that they are competent in, or at least that's the hope. And you create an organization that is created and empowered by the legislature, and then the legislature says, go forth, do your thing. So the last category of law is really old, and it's a lot older than I realized when I went to law school. And it's law made by judges. And this law is called common law or decision law. And so what will happen is you'll have a court case, and in a court case, the way it proceeds is you have two people who are arguing about something. And this is something that
specific
happened,
question and situation.
A specific, hyper-specific situation.
Yeah.
And then they will be arguing about whether or not something happened, and then if the thing happened, what to do about it. So the classic case that people are aware of from the movies is like a murder trial. And so the first thing you want to argue about is the facts, whether or not you can prove that so-and-so did the thing. And so you're trying to prove that so-and-so did the thing, and you try to get the evidence in, and one side's saying, no, that doesn't count as evidence, and the other side is, yes, that counts as evidence. And then there are rules that the court has to follow about what counts as evidence and what doesn't. And then, the court case is done. Boom, you've reached a decision. Well, the first layer of court, this court that happened in, is called a trier of fact. But what if they got the rules wrong? Or what if the rules themselves were ambiguous? Or like it's an edge case and it's like, does that really fit the definition? Are we really sure that this counts? We're really not sure. And so, gosh, I really need an example there in order to
Well,
clarify that.
here's one is, gosh, I can't remember when it was. I swear it was in the early 90s or late 80s, but the Peyote Case, right?
Oh, yeah.
So there was no doubt, right? This is, goodness, and I can't remember all the specific details of the case, but basically there's a Native American tribe. They smoke peyote as part of a religious ceremony. It's outlawed, is my understanding, this drug peyote, right?
Yep.
And so they're put on trial for the criminal offense of possessing and using peyote, right? And their defense is based on the First Amendment, right? So there's no doubt that they smoke the peyote.
Yep.
They said, hey, we smoked the peyote, right? Instead, the question is, well, wait a second. Is that or is that not protected by the First Amendment? So it's not a question of the facts of what happened. It's a question of what the law thinks about the facts, how the law will apply to those facts.
Exactly.
Yeah.
So is there an exception for religious conduct? Because suddenly you have, the law conflicting with this general principle of free exercise of religion. And so how do you settle this? This is where a court of appeals comes in. So the first layer court is called a court of fact. They really only deal with the facts, and occasionally they get the law wrong, or the law is ambiguous. If the law is wrong or ambiguous, you move up a level, and you can throw in an appeal. You cannot throw an appeal for facts.
Yeah, when you appeal up, generally speaking, the facts are already decided.
Yep.
That's decided by the jury trial.
Yep.
Instead, the question is, okay, wait, we already know what happened, but what does the law really say about it? And that's the question.
Right.
And that's what's developed through case law, which is judges making decisions over time that then define and channel what the law means in terms of practical application.
Exactly. And there's really two situations that you get into that lead to this kind of ambiguity. One of them is when one or more laws conflict. I took a class last semester on the conflict of laws. We live in the United States, which has lots of states, and lots of states have lots of different laws. And you can imagine situations where the laws of one state conflict with the laws of another state. It happens all the time. And so we have a separate series of decisions and principles that courts will use to figure out what to do when two laws conflict. Or it could be that a law was just written badly and by a legislature, and so suddenly it leaves all these holes and room for error and questions, and so they have to be resolved because it has to apply to real people. And so, a court case only happens if there has been an actual controversy with two people who have argued through one layer of courts already. This is the threshold that you have to pass in order to get into the courts of appeal, which end up, by their decisions, creating the law. And the way they're creating a law is when they decide how one case goes in these ambiguous situations, if a similar case like that comes up again, it would not be just to give a different answer. So the idea is you just want to be consistent with prior decisions.
Which is stare decisis, let it stand.
The Latin for it is stare decisis, and that's the general principle of the common law. It's basically, if something's been decided, don't decide it again.
Although this is not universally, I know it's generally true, but this is not universally true. For instance, you have the Plessy versus Ferguson decision, which establishes the segregationist doctrine of separate but equal.
Yes.
And then a century later, you have Brown versus Board of Education, which flat overturns it, right?
Yep.
And basically just says, hey, we decided Plessy versus Ferguson wrong.
We got it wrong.
Yeah.
And so they will do that. Thank heaven that they're able.
Rarely.
It's extremely uncommon, but stare decisis is what you'd call a strong guideline rather than an absolute rule. So if they make a mistake, or if times change such that, or if they realize that they made a mistake, really, if they realize they made a mistake, they can go back and correct that law. But doing so is messy sometimes, particularly when it deals with structural stuff in the government. Messy but necessary.
Okay.
So that's the general idea. That's the idea. So basically,
of how case law is made and how it is that the judiciary makes laws.
Yep.
If you don't mind me raising just one other example, so actually two other examples if I could. So the fallout from the Peyote decision was actually that the Supreme Court, I believe it was the Supreme Court, I don't know how far it went in the appeals process, but decided that peyote is not protected by the First Amendment.
Right.
Peyote as part of a religious what do you call that, ceremony is not protected by the First Amendment protections on religion. Right, and so that now defines what the law says. Yep. Right, so, another example is, for instance, Roe v. Wade, right, where there's nothing explicitly in the Constitution about abortion, but after that, the Constitution, particularly, I believe, the 14th Amendment, I think.
It was under the penumbra, so it was the idea that there are rights that are not explicitly included in the written law.
Yeah.
The idea that there's extra rights floating around, which is an idea that's contained in the Ninth Amendment. Yeah.
So the idea is so that's not previously it's not part of the explicit text of the Constitution, but now it's interpreted as part of the law. So there you have situations where judges are making law.
Right.
Okay.
So you can imagine the way that this works from kind of a basic level. The way that I see judges making law or ruling on cases is more or less about the conflict of rights. Rights are not absolute. I have a right to life, so you do not have a right to kill me. You have absolutely no right to kill me because I have a right to life. But if I'm holding a knife to the throat of your daughter and, it's her life or mine, then you are justified in blowing me away. Just so my right to life could be trumped by something else.
Yes.
By your right to self-defense or the right to the defense of your family.
Sure.
So that's the general principle. So if we got into that situation, you can imagine, this horrible situation where I died, my widow takes a case against you and says, hey, he killed my husband. And, that's true. I mean, that's the fact. But the question is, whose right trumps in this case? Mm-hmm. And then the law develops over many, many, many cases, basically trying to establish a hierarchy of how we're going to deal with rights.
Okay, so if you're ready to pivot, that's sort of the background, right?
That's
if you're ready to pivot into sort of the evaluation of that, when we talk about judges making laws, then one of the common phrases that will come up is, of course, judicial activism.
Yep.
And this has been a complaint particularly from conservatives and Republicans for a very long time, right?
About judicial activism. Democrats
more recently also from the liberals and Democrats, right? Particularly because there's roughly a 5-4 conservative majority on the Supreme Court, depending on how you slice it precisely.
Exactly.
Right.
And it will depend on the issue.
Yeah. So lots of people have sort of a negative reaction to judicial activism, right? And you mentioned a little bit that your views on that have changed a little bit over the time. How do you feel about case law? How is it good and how is it bad?
Well, so the danger is that judges are not elected. So there's this deep distaste for having someone who's not elected making the rules. It's kind of scary, really. But
it's hard for people to be accountable, especially if the judges are appointed for life.
Especially if judges are appointed for life. Absolutely. So, I mean, that's kind of the reason why to be anxious about it. The reason why I like it is because of Burkean conservatism, funny enough. The thing about a legislature is that they can get creative at any time. And I think creativity is an extremely bad quality for a lawmaking body to have. What I like, so a legislature can decide at any time to make anything illegal. Mm-hmm. There's an old quote that no man's person or property is safe so long as the legislature is in session. Uh-huh. So there's a predictability problem. Second, there's some game theory problems. A legislature just has to get a 51% majority in order to make some things happen. Mm-hmm. And so you can imagine cases like, for instance, the battle with the Affordable Care Act in the mm-hmm. United States, where you get a party that gets 51% and over majority that realizes that they can suddenly pass things according to their wishes. Mm-hmm. And rather than having a kind of adversarial system like you would normally have, where you raise ideas and have them discussed down and shut down, you get parties taking over a legislature. Mm-hmm. Totally expected. When you then pass that through, or ram it through, if you don't like the proposal, you'll say ram it through, you then get a party switch because, enough people were upset that it changes mm-hmm. who gets elected into the legislature, and then it's actually harder to get things out than it is to get things in, which is a funny thing, which means the law will accrue over time. You will get more and more law added without the same amount of law taken away.
It will encrust, it will accrete.
It will encrust, accrete, exactly.
Like barnacles on the hull of a ship.
Exactly. And the ability for it to change fast, let's say that there is a national crisis or something that's in the news that makes everybody mad at the same time, mm-hmm. but it's the kind of thing that's going to make everybody mad for, say, 6 months, not for forever. During those 6 months, if you get enough of the legislatures mad, that thing will cause a law. Mm-hmm. And so legislatures are unstable in a way.
Oh, I'm thinking an example of this, if this is an example of what you're thinking, is the Patriot Act, for example, right?
Oh, yeah.
Where I don't think that the Patriot Act has that widespread of support on right or left right now.
Yeah.
But just try getting rid of it.
Yeah.
Right. First of all, you need to find somebody in Congress who's willing to do it, and I think that would be
and then
by itself pretty difficult.
The name, the Patriot Act. Yeah. So anybody who's going to vote against this is what? You're not a patriot?
For sure. Although even name aside, right? There's this thing here that you're talking about where it's an inherent nature of laws that they're very difficult to undo for some reason.
Yes.
We just have a lot of trouble unpassing laws. Congress doesn't do that very much.
And on top of that, there's one more thing I want to add, and this is a kind of a theoretical concern. There was a mathematical proof done in 1931 by a guy named Kurt Gödel. And we did a video on this recently called, I think it's called Why Math Isn't Everything, the Paradox of Kurt Gödel. And what he proved was that mathematics was inherently either inconsistent or incomplete, as will be every single system that you can devise that tries to be complete. Mm-hmm. And so you think about legal codes, a series of statutes collected into a code that's supposed to deal with an issue, say the criminal law. And you create an exhaustive list of all the ways that you can possibly commit a crime. Here's the thing. You have suddenly created a creativity battle between the legislature and the most creative criminal in the future that's going to be dealing with future context and future everything. And so the question is, can you, with the law that you've written, imagine everything that could possibly ever happen and get it to pass? And the answer to that question is no, probably not. And so there's technical problems because statute, or at least certain types of law, involve predicting the future, and they also involve creating a closed, complete system. You run into mathematical problems trying to model all of law in something that you can explicitly describe, write on paper, and then vote on. And so you run into these problems. What I like about judge-made law, which accounts for some of these problems, is that for one thing, it only changes if people are actually harmed, which, sounds kind of terrible. You don't want people to be harmed in order for things to change, but you can't have the problem of the legislature just deciding to do something, because you actually have to have the people in front of you in your courtroom with a specific problem that actually happened, a specific problem in the law that actually needs to be remedied and needs to be corrected by a decision.
So you can't have, you read about these silly laws like not fishing for whales in Minnesota or whatever.
Yeah, it's never going to happen.
And you can't have that because someone would actually have to fish for whales in Minnesota for it to make it into the court system.
Right.
So you've already restricted the set of problems that you have to deal with down to only the problems that actually exist.
And only the problems that actually...
Not hypothetical problems that may or may not
It
exist.
might be better to say, instead of things that have actually hurt someone, rather things that someone actually cares about and can show some kind of harm from.
Uh-huh. Or at least can make a case for.
Can make a case for, yeah.
I mean, that's why you're there in court, is to figure out whether or not really harm was done, whether or not something needs to be done about that harm.
Absolutely. Absolutely. Yeah, so I like that filter mechanism. The filter of it has to pass through that filter, which means that the law does change, and it changes in an ongoing way based off of these decisions. But for one thing, the body of law is not complete, because you're taking into account in a courtroom things like custom and what a reasonable person would do. And what would a reasonable person do? It's kind of hard to define, except in very particular circumstances, which is what judges are capable of dealing with.
Well, and that's what all courtrooms deal with, right?
Yep.
Is it always deals with the particular.
Yes.
Whereas the legislature, by its nature, deals with the general.
Yes. Now, so that's generally speaking why I like judicial law where possible. I like the common law. The common law has come up with some really wise things, and as it's developed, I've been really impressed with it. I like the general principle. Now, in the American Constitution, there's some caveats that make judges a lot safer than I think they would be perhaps with another system. In Article 1...
Safer meaning they can't
more
be
restricted.
Punished for their decisions, or that the system is safer for citizens and their rights and well-being?
That is an excellent distinguishing, yes.
Well, I just wasn't sure what you meant.
The second one, not the first.
Oh, okay. So it makes the system safer for humans.
Yes.
Okay.
System safer for humans. The way that happens is in Article 3, when the Constitution is defining the powers of the judiciary, it actually does a terrible job of defining it. It more or less just says, go forth, judges.
Be judges.
Yes,
just
go
do the judge thing. Do the judge thing.
And
which is a thing that they could do, because you have that whole British common law backing up the American tradition, which means that they know what it is judges do.
Yep. And all of the...
Whereas, for instance, no one really knows what the American president is supposed to do when you pass the Constitution. It's like, well, we haven't really had this before, right? But the judges know what they're doing.
Yeah.
Yeah, okay.
It's funny, all the American founders who were trained in the law were trained under a tradition called Blackstone, which was basically where you become an apprentice to an existing lawyer, and then you read Blackstone's commentaries on the English law for your education. And as you're reading those, Blackstone makes the argument that judges are in the process of discovering the law through cases. and that they operate through the natural law. Basically, there's justice, which is kind of this like ethereal concept, and then you're always trying to pin it down to the specific cases. And as you do so, you've revealed a little bit about the principles, a little bit about whose rights trump whose in what situations. And over time, that reveals kind of these patterns of justice that we call the natural law. Mm-hmm. And, that's kind of interesting. So, I mean, this is the training that the founders were given in law, generally speaking, mm-hmm. at least the ones who had legal training. But in Article 3, it also sets out that there's only one court that's defined by the Constitution, which just says a Supreme Court. How many judges? We don't know. What do? Well, we give them a list of things that are original jurisdiction, and then they also take care of other appellate matters.
Still very general.
Very general. And then
it also says that they'll make lower courts, but it doesn't prescribe the number, doesn't prescribe the organizational schema. That's done by law afterwards, right?
Yes.
So Article 3, the Judiciary article, is very vague.
Very vague. But it specifies that it is the legislature that ends up making these other courts. And so the legislature gets to control what the rules are that are used in the court settings. For instance, nowadays they create the rules of the Federal Rules of Civil Procedure. And that's not nothing. They also create the rules of evidence. So the rules for how a court will operate, the playbook by which judges will judge, is created by the legislature, which makes sense to me. I mean, that's a good system. Basically, I think that there are some types of law which have to be centralized or have to predict the future. For instance, budgeting. Mm-hmm. If you're going to make a budget, you don't want a judge to be making a budget after the fact. That's a terrible, terrible way to do things. You want a budget to be made before the fact, and you want it to be made with all the available information gathered together so that you can kind of get a sense for how things are going to go. And you kind of have to. There's no other way to do a budget. Mm-hmm. And so it's interesting that in Article 1, the Constitution gives the power to make budgets to the legislature, but the list of powers given to the legislature is an exhaustive list. It's supposed to be, you have these powers and no more.
Yeah.
Which, where do the powers that are not on that list go? Evidently, they're going to go to branches 2 and 3. And I think,
or to, as the 10th Amendment says, to the states or the people.
Yes.
Yeah.
But yeah.
Okay, so there was something that you didn't bring up, but we've talked about a little bit. So fundamentally, what your paper is doing is you're defending the idea that the mean, nasty name for this is judicial activism, but really what it is it's case law, right? The common law, and you're fundamentally defending the common law. And let's kind of try to specify out the grounds, and we'll do some backtracking and go back to the ideas that we've talked about earlier.
I want to distinguish real fast because it's not judicial activism. Judicial activism is when you get a judge who stops trying to make judgments based off of individual cases and instead tries to make them based off of political preferences. Mm-hmm. And that I do think is incredibly dangerous.
Yeah.
It's been a problem a number of times in American history. We've had some courts, funny enough, particularly in California, it's kind of known for it. They get overturned a lot because...
The Ninth Circuit.
Yes, the Ninth Circuit. Is it? Yeah.
I believe it's the Ninth.
And I do think that's a problem. Judges need to be selected based off of their ability to judge well. And that requires an interest in the particular circumstances and a deep, temperamentally conservative approach toward existing common law. I don't mean politically conservative. I think... political leanings will be what they will be, but temperamentally, they need to be averse to change that is too fast. Mm-hmm. Not averse to change entirely. We need change. The common law needs to develop in order to be alive, but slow change. Mm-hmm. The minimum necessary damage to the existing law.
Well, and one thing that we've talked about a little bit that we haven't brought out yet is the fact that you can easily construe the common law, in other words, judge and court and case law, as a more appropriate technology for making laws than the legislature, right? The legislature can make any laws, right? Roughly speaking, right? You make laws for hypothetical future cases, whereas the court system is A, distributed, right?
Yep. So it's closer to the ground in more places, and it can be more different in more places.
And B, it's more connected with the particular circumstances, right? Because you can only litigate what actually happens. You can only litigate things where there is a specific problem that has occurred or is occurring, right?
Yep.
Whereas the legislature can make, if you want to go to the very extreme end, they can make laws about, not eating ice cream cones on the back of camels or what have you.
Or all these ridiculous laws we've heard about.
Exactly,
I think not whaling in the Great Salt Lake is one of them.
Oh, yeah. See, yeah. I have all the little pieces, right? Ice cream cones, whales, whatever, camels. I just can't piece them together in the right order. So there's two advantages, right?
Yeah.
Is one, it's distributed. B, it responds, 1B, two, it responds only to very particular circumstances. Another one, which seems to me the third, is that it's more stable, right?
Yes.
Where the legislature, right?
And stability is a value in any political system.
Well, and particularly in law, where you
base your life around it.
You need to be able to know what to expect.
Yep. You need to be able to make predictions about the future, and that requires something that is stable. Yeah. So stability is a good thing.
So now, there's three advantages right there that in my mind, I look at that and I'm like, oh, okay, well, that means that case law, generally speaking, is a more appropriate technology for making laws than legislating.
Where available. And that's, so the main idea of my article that I'm writing is, my paper, is that there is a fundamental difference between types of law, like budgeting, which have to be done. In order to be coherent or make sense, they have to be done by a centralized representative voting body like a legislature. Another thing is planning a military expedition. You don't want judges doing that in a distributed fashion. That's a terrible, terrible idea. Mm-hmm. But dealing with property disputes, there's no reason why a Congress should get involved in that beyond the minimums. There is no reason why they should be involved in tort law. And funny enough, there's a lot of areas of law that can be kind of subjected to a hybrid approach, where they can kind of be given or passed off to the judiciary. I took a class last semester on antitrust law, which was fascinating. Antitrust is all about anti-monopoly law. And the way that it works in the U.S. was like this. I mean, we had the robber barons, these people who were amassing huge monopolies around at the turn of the century. And so we created an act called the Sherman Act. And it was created by a legislature, by the legislature of the United States, that basically said all restraints of trade and all these monopoly type things are hereby illegal. But they wrote the most dismally awful statute you can imagine. Because if construed literally, the first couple sentences mean that all contracts and all business partnerships are illegal, which can't be right. And so the Supreme Court got a hold of this document and people suing under it and basically said, we're going to write the word reasonable into it, mm-hmm. which is awesome because now it's the
only way it could be properly enforced at all.
It's the only way.
In some sense, the legislature is kind of, you're saying, a little bit like a computer in the sense that sometimes it puts out garbage, right? And it can't tell that it put out garbage.
Right.
But the courts is like a human being who comes and looks at it and can piece out, okay, wait a second, this is what's right, this is what's wrong, and it needs that human attention.
Yes, and it isn't the court that's discovering this, it's the people on the ground that are bringing their cases to the court mm-hmm. that are actually discovering this. It puts people back in the driver's seat in a way to be changing and, mm-hmm. and working with the law. And so the interesting thing about the relationship here is that the law then, from that point on, from the Sherman Act forward, with a couple of more statutes being introduced, but mostly it's been carried out by case law. Mostly, I mean, that's how it operates in the United States, is by case law. But the funny thing about it is the Sherman Act creates both civil and criminal penalties, which means that both regular people can sue and also the government itself can sue. And when the government itself is suing, that means an executive branch. In this case, it's the Department of Justice and the FTC, the Federal Trade Commission. And they act as prosecutors, mm-hmm. which is so cool because suddenly the executive branch is not just making rules. They're acting as prosecutors. They're going out hunting, looking for people who are violating this law, bringing them to the court, and then the court decides, yay, nay, this does count as a problem, this doesn't count as a problem, and the law develops through the court. Mm-hmm. And so it's like the mandate was given by the legislature, passed off to the courts, and then a role was given to an executive branch, which makes perfect sense, but didn't give rulemaking authority, really, to the executive branches. And so I think it's an incredibly healthy way for the three branches to interact, where the rules on the ground, all the little additions that need to be made in order to keep it up to date and have it make sense are done by the courts through the adversarial process. One of the adversaries is the executive branch, which is acting as a prosecutor and executing the law. And then you have, the legislature just basically saying, hey, this is a problem, you need to go take care of it. So the same thing that they would do in creating an ABC soup organization, they did passing to the judiciary.
So I'm curious because I made clear my opinion. I think that the right way to think about it is that it's an appropriate technology. I'm curious if you agree with that, right? And roughly speaking, what that means is, are the principles, are the roughly the same principles that undergird the other projects we do on this channel operating in the common law, case law, an appropriate technology?
So one of the things, appropriate technology is about a technology that is different and possibly better for a specific set of circumstances. In that sense, yes, absolutely. I think it's interesting because the problem is interesting, and it's worth talking about here on the channel because it brings up fundamental questions about how it is best to organize and rule. And fundamental questions are what I'm interested in, getting back to the basics, to understand things at their core. And one of the ways I like to do that is by looking at the different ways it could be done. It's interesting to see that there are advantages and disadvantages and brought about by the three different types of lawmaking. And we like things to be representative and democratic, but we also like things to be close to the ground and slow to change. And it's interesting to try to balance these two values. So yeah, I'll say it's an appropriate technology. It's interesting. Anyway, I'm still writing the paper. I'm still trying to get my thoughts out. But yeah.
Something certainly well worth considering. The law is something that affects all of us, and it's not the only fabric of our society, but it's certainly a very important fabric undergirding everything, right?
Yeah, it's what happens after conflict happens, really.
And so it's a thing that's certainly worth thinking about. Okay, all right. Well, I think we'll close that up for today. So we want to thank you again, all of you, for listening. We hope you enjoyed the podcast. Please give us a like and subscribe, and we'll see you next time.